Audio check. Audio check for closed captioning.
it's all in like these monthly blogs. See that this is prominent beauty blogger. Well, if she put them all on, it's the before. Yes, and it was like one of us to be like, where would you go? Oh, there's a prominent mommy blogger who just came out of this huge confession that 95% of but I think so. I don't know if it was her, but she came out and said 95% of what I wrote was like I was promoting products that I not even was even free stuff. I was just reporting things to them outside the law, not necessarily scientific. And these things spread like all over the internet. I think that phenomenon is like certain moms will do it, and then they'll subconsciously think, just see some improvement that may or may not actually exist, and sort of like hoping about sugar rises. That's totally bogus. Kids who eat sugar, they start getting why. They've done tons of studies comparing kids that were eating sugar and not eating sugar. And it's just like their moms who superimpose on kids who think, well, it must be because of sugar. It must keep them out of sugar. They get disease. Everybody believes that. Yeah, no, it would, but like, just fast forward. All I'm saying is that those studies of kids who've done that, and by the time they're in fourth or fifth grade, it is not all that matters. Like, who cares what the difference is early on if it all dissipates by the time they're 4 or 5? And meanwhile, you're spending your life on it. You don't expect them to.
Oh,
They just
yeah.
can't.
All right. She said you were
Douglas
here.
Park, yeah, public school.
To,
Yeah, good public school. In Arnold,
no question.
oh, you know, where are you? What's school?
They both have very similar doors. This was the
Subcommittee on the Constitution and Civil Justice will come to order. And without objection, the chair is authorized to declare recess the committee at any time. And welcome to you, gentlemen. Sorry for being a little late. We've called this hearing today to examine H.R. 3765, the ADA Education and Reform Act of 2015, and H.R. 241, the Access Act of 2015, which are two common sense proposals that require plaintiffs to provide defendants with written notice and an opportunity to correct an alleged ADA violation voluntarily before they may file a lawsuit and force a business owner to incur legal costs. These bills, which only apply to cases involving public accommodations, would both improve public access for disabled individuals and eliminate thousands of predatory lawsuits and that damage the reputation of the ADA and its overall purpose. When the ADA was signed into law by President George H.W. Bush in 1990, the goal was to provide the disabled with equal access to public facilities. And in large part, the ADA has worked. It has been hailed as the most sweeping, non-discrimination legislation since the Civil Rights Act of 1964. Unfortunately, enterprising plaintiffs and their lawyers have abused the law by filing a flurry of ADA lawsuits aimed at churning out billable hours and extracting money from small businesses rather than improving access for the disabled as the ADA intended. These predatory lawsuits are possible for two chief reasons. First, 100% compliance with the ADA is very difficult to achieve. Even though good faith efforts such as bringing or hiring an ADA compliance expert, a business can still find themselves subject to a lawsuit for almost any minor or unintentional infraction. According to one ADA compliance specialist, quote, "I rarely, if ever, see circumstances or instances where there isn't an access violation somewhere. I can find something wrong anywhere," unquote. This makes compliance a challenge, even for those with the very best of intentions. Second, unlike Title II of the Civil Rights Act, the ADA does not currently require any notice before a lawsuit can be filed. This has led to thousands of lawsuits being filed for issues of relatively minor noncompliance, such as a sign being the wrong color or having the wrong wording. Abuse of the ADA has been noted by federal judges in numerous cases throughout the country, who have referred to the proliferation of ADA lawsuits as a, quote, cottage industry. These judges have recognized that the explosion of private ADA litigation is primarily driven by the ADA attorney's fee provision. One federal court explained that, quote, "the ability to profit from ADA litigation has led some law firms to send disabled individuals to as many businesses as possible in order to have them aggressively seek out all violations of the ADA," unquote. Then, rather than notifying the businesses of the violations and attempting to remedy them, lawsuits are filed. As settlement prior to filing a lawsuit does not entitle plaintiffs' counsel to attorney's fees under the ADA, there is an incentive. As one federal judge observed, the result is that the means for enforcing the ADA attorney's fees have become more important and desirable than the end, which is accessibility for disabled individuals. But the ADA was enacted to protect disabled individuals, not to support a litigation mill for entrepreneurial plaintiffs' attorneys hunting for ADA violations just to file lawsuits. These bills examined today would help eliminate predatory ADA lawsuits, increase compliance with the ADA by giving businesses the opportunity to fix ADA violations instead of dragging them into litigation, and improve the reputation of the ADA in the eyes of the public, and ultimately improve access for disabled individuals. Lawsuits would be reserved for those instances in which offenders are truly unwilling to make appropriate changes. This would also allow legitimate claims to move through the legal system faster. Moreover, requiring notification before filing an ADA lawsuit will benefit our economy. Many small businesses have been forced to close because of accessibility lawsuits, and others have unnecessarily spent thousands of dollars litigating claims. Small businesses are critical to America's economic recovery and should not be burdened by unnecessary litigation. It's an honor to have Congressman Ted Poe, who introduced 3765, and Congressman Ken Calvert, who introduced H.R. 241, both here to testify about their respective bills. And I look forward to your testimony and the testimony of our other witnesses. And with that, I would recognize the ranking member of the subcommittee, Mr. Cohen from Tennessee, for his opening statement.
Thank you, Mr. Chair. Colleagues, it's good to have you all here. This is not the first time there's been a hearing on this type of issue. Since 2000, there have been, I think, 3 times that bills have been filed and hearings on pre-notification concerning ADA. I have met previously with the folks from the shopping center world, the hotel world, and the disability community, and tried to get a better grasp on the issue and come up with some type of a reasonable solution. It's difficult to do it. The folks don't really want to change from their kind of positions they've got. Some of them are based in 1990, and they'll tell me that this is what we did in 1990, and it's kind of like, well, that's fine. I wasn't there in 1990, and my job is not to ratify whatever happened in 1990. But when we look at these cases, private parties are indispensable to having enforcement of any civil rights law, and this is a civil rights law, so we've got to have private attorney generals, and private attorney generals have been so effective in many areas in seeing that our laws are effectively enforced, civil rights in particular, and the ADA. And because of that, there was the agreement in 1990 said that there wouldn't be damages in these cases under the ADA, but they would get attorney's fees, and so that gave, it was a compromise that was done. I understand that there's some folks that think that there are attorneys out there throwing out wide nets, and they don't really have a specific target, and I think that's wrong. I definitely think that's wrong. But I've suggested to them that in coming up with some type of solution, and part of that's in the bill, I think, is that you have to have specificity in your complaint, and you could tighten that up to see that they have not just a boilerplate complaint, but a specific complaint, although I don't know why Rule 11 hasn't worked against those type of complaints in the past, but so be it, maybe that would help. If you get into this situation to where you obviously the title of this hearing is the examining legislation to promote the effective, I know it's effective, enforcement of the ADA's public accommodations provisions. So we have to presume in there that we want to enforce the ADA's public accommodations provisions, although most of what we've got here is not so much for enforcement as kind of limiting enforcement and limiting the way we go. So that's kind of a juxtaposition in my mind, or contradiction in the title and what I see as the focus of the legislation. I've never seen a criminal penalty that would be created to anybody who asserts a civil right, and this would be a case that when you could have a civil penalty, criminal penalty, excuse me, if you don't give your notice provision first, and that seems really harsh, and I think some of the folks have agreed that was a little harsh and maybe further than it should go, and I can't get it, that would be anathema. But there can be abuses. I think there might be abuses, and if there are abuses, I want to clean them up, and I did that with this committee and looking at trolls that are, and I know they're not your pals, Mr. Poe, but they may be, but I don't think so, in Marshall County, Texas deal, and they're just kind of, it's not necessarily a great world there. So I've suggested if you want to amend this and have pre-suit notifications, that you ought to have something that also rewards the good guys that clean up the mess after the 120 days, and everybody says, oh, the good guys will come forth, they get notice, and that's what you want to get, is you want the mirrors or the signs or the rails or whatever taken care of. And if the good guys do it, make substantial compliance, great. But if they don't, you got bad actors, or if they just kind of lollygag, or they don't do substantial whatever, then I think you've got to have a stick. And if you're going to change this, you've got to have a stick to see that the bad guys get punished somehow. And I'm not quite sure how you do it, but there's got to be something to those people, not just to give them this notice provision and time to kind of maybe be dilatory, but punish them for not being good guys. And one of my thoughts was to give some kind of damages, some liquidated damages, maybe some amount that's equal to or some multiple of what it requires to fix the area, or maybe there'd be some other kind of damages we could come up with to punish the owners that aren't the good guys. You've got to have consequences for those people, and otherwise they're just getting a benefit, and they're not being the folks that I know that Mr. Poe and Mr. Calvert are interested in helping through this action. And the folks with the ADA community, I mean, they want, like I want, the ADA enforced. And this is not about attorneys, this is about ADA provisions. But the attorneys do bring the cases, and with the notice provision, they don't have, and not getting attorney's fees, they bring a problem to the attention of the business community and they clean it up, and the other side gets nothing for it. There's unlikely there's going to be a continued interest in those people, the attorneys, to follow through and help in giving the notice provisions, advising the clients, and trying to cure problems with the ADA. That's just the way the system works. People have got to have some skin in the game, and you're taking the skin in the game out. And so that's going to hurt, I think, the enforcement here, unless we come up with something on the back end that maybe kind of makes it a little bit sweeter. I'm a lawyer, and I have a disability. I helped pass the ADA state statute in Tennessee, and I'm interested in seeing it's enforced appropriately and properly, but I'm not interested in seeing businesses get these wide nets thrown and be subject to folks looking out more for attorney's fees than the disabilities community. I think that's a disservice both to the Bar Association, members of the bar, and to people with disabilities. So I hope we can have a fruitful discussion. I know we will, and hope we can come up with a solution. I think there's some good ideas here, but I don't think the solution's here, and I do think we need to look at some kind of a stick to make sure the bad guys get slapped so that the good guys can just deal with a notice. With that, I yield back the balance of my time. And that's just the way it is.
I thank the gentleman, and I would now yield to the ranking member of the full committee, Mr. Conyers from Michigan.
Thank you, Chairman Franks, and top of the morning to you and our distinguished witnesses and the guests that have joined us this morning. The three bills that are subject of today's hearings would institute a notice and cure requirement under Title III of the Americans and Disabilities Act of 1990. Specifically, these measures would prohibit a lawsuit from being commenced unless the plaintiff first gave the business owner specific notice of an alleged violation, an opportunity to fix or make substantial progress toward remedying such violation. Let me begin by stating what I said previously when similar proposals were considered by our committee in the year 2000 and again in the year 2012. Quote, I am adamantly opposed to any effort to weaken the ability of individuals to enforce their rights under Title III's public accommodations provisions. And here's why. First, the notice and cure requirement will generate numerous litigation traps for the unwary and ultimately dissuade many individuals from pursuing their legitimate claims. For example, two of these bills would require a complainant provide specific notice of the alleged violation before he or she may file suit, but they fail to define what constitutes specific notice, nor do they define what is substantial progress toward compliance. As a result, courts will have to struggle to determine what these inherently vague terms mean, thereby creating an open invitation for well-financed business interests to engage in endless litigation, possibly, that would drain the typically limited resources of a plaintiff. In addition, these measures would undermine a key enforcement mechanism of the American with Disabilities Act and other civil rights laws. The credible threat of a lawsuit is a powerful inducement to businesses to proactively take care to comply with the Act's requirements. Yet a pre-suit notification requirement would create a disincentive to engage in voluntary compliance, as many businesses would simply wait until receiving a demand letter before complying with the law. And this requirement also would discourage attorneys from representing individuals with claims under Title III, because attorney fees may only be recovered if litigation ensues. Thus, an individual with a Title III claim would not be entitled to recover such fees if the extent of the attorney's representation was limited to drafting the demand letter. Pre-suit notification would make it even more difficult for disabled persons with valid Title III claims to obtain legal representation to enforce compliance with the Act. Finally, Title III, by its terms, is already designed to make compliance relatively easy for businesses. And so I am pleased to join the hearing and yield back any time remaining. Thank you, Mr. Chairman.
And I thank the gentleman. And without objection, other members' opening statements will be made part of the record. Before I introduce the witnesses, I would like to submit two statements for the record. The first is a letter from the National Association of Theater Owners in support of H.R. 3765. The second is a coalition letter also in support of H.R. 3765. Without objection, these statements will be entered into the record. So let me now introduce our witnesses. We have two very distinguished panels today, and I'll begin by introducing the first panel of witnesses. Our first witness is Representative Ted Poe. Mr. Poe represents Texas 2nd District and is a member of the Judiciary and Foreign Affairs Committee. I'm glad to see you, sir. And our second witness is Representative Ken Calvert. Mr. Calvert represents California's 42nd Congressional District and is a member of the House Appropriations Committee. I'm glad you're here. And so I would now recognize our first witness, Congressman Ted Poe. And if you'll turn that microphone on, I know you'd. Yes, sir.
Thank you, Mr. Chairman. Thank you for allowing me to be here, and I want to thank the ranking member. And also, I would like to thank Congressman Calvert for his work on this issue for a good number of years. As the chairman has pointed out, or has pointed out in the past, I'm a former judge, prosecutor, and lawyer, been in the legal profession for almost 40 years. And this is a situation where this particular hearing that we're having deals with, I think, abuse of a good law. I believe strongly in the ADA, and it needs to be always enforced. And the goal of the legislation is to make sure that when there is a violation anywhere across the fruited plain, that the violation gets fixed so that there is accommodation for the citizen to get into that business. But the legislation hopes to prevent what is occurring, that there are lawsuits being filed not to get accommodation for the citizen, but to get money so that people settle, and the alleged violation may or may not ever be addressed. And what happens is that lawyers are making a lot of money off of these, what I think are frivolous lawsuits, to the detriment of the person who is actually being prohibited from going into some businesses, because the goal is not being reached to allow accommodation. What is happening is lawyers are filing lawsuits, businesses settle rather than go to court, and the lawyer gets, we don't know how much of that money. So in the last 10 years, there have these frivolous lawsuits have been filed under the public accommodation section of the ADA. Some of these lawsuits are, in my opinion, shakedowns for businesses. And they're using the ADA as a basis to obtain quick settlements rather than go to court. For example, some of these law firms, and there are specific law firms in different parts of the country that do this, they will file a notice or give a letter stating that there is not a proper pool lift in a particular motel or hotel. And some of these hotels don't even have a pool, or these motels. But the businesses settle rather than go to court because of the cost of litigation. And that is the motivation of these lawsuits. And we're talking about settlements of around $5,000 apiece. Often the same individuals or organizations who are making many of these claims go from business to business. And it's a business model that's been working, especially in the last 2 years, where 10,000 of these lawsuits have been filed. In Florida, a plaintiff named Howard Cohen, no relationship to the ranking member, has filed 529 of these lawsuits. California, Martin Vogel's filed 124. In Pennsylvania, Christopher Milo has filed 21 of these lawsuits. And in some cases, like Howard Cohen, he sued the Marquesa Hotel in Key West for an alleged violation of their pool, despite the fact he was never a registered guest at the hotel. Sounds somewhat suspicious. The ADA expert who actually wrote part of the ADA bill, Bill Norcus, helped the hotel fight in this particular case. And he stated that Cohen was essentially operating, quote, a continuing criminal enterprise that boils down to extortion. That does not get people into these motels. It does not accommodate these individuals. It allows for, as he said, shakedowns for money to be collected by these, as I think they are, ADA trolls. And some of the letters and notices are so nebulous that the person receiving the notice doesn't even know what the violation was. We have a realty company in Houston manages many shopping malls, and in one particular shopping mall, there's 40 parking places that are painted blue and ADA compliant, but they're still sued because the violation doesn't allege, or the letter doesn't allege what the specific violation is. So this bill will require basically three things: that they be put on notice so they can fix the problem before there's a lawsuit. If that's the goal, to fix the problem, put the business on notice. If the business doesn't respond to this notice within 60 days, lawsuit commence. If the business then doesn't fix the problem within 120 days, and I think that could be worked on how many days, file the lawsuit. That does not prohibit the citizen from filing and getting their day in court, but if we want to fix the problem, let's fix the problem. It also allows for arbitration if the sides want to arbitrate. It's not required under the law. It's voluntary, and it also requires that the Justice Department come up with some very working with the industry and the people in the ADA community, different models on how they can educate all businesses throughout the country on what the ADA says and how they can comply with the law as it is written. So that is why this legislation is. It's to put them on notice, fix the problem, get it ADA compliant. It's not to really allow for these frivolous lawsuits to be the money going to, I think, the attorneys rather than fixing the problem. And I'll yield back my time, and that's the way it is. Or the chairman.
And I thank the gentleman, and I would now recognize our second witness, Representative Calvert. And sir, if you make sure that microphone's on.
Thank you, Mr. Chairman, distinguished members of the subcommittee on the Constitution and Civil Justice. I thank you for the opportunity to testify today on H.R. 241, the Access Act. As you know, the ADA, has been mentioned, is undoubtedly one of the most important pieces of civil rights legislation that we've passed in this country. We can all agree that providing all Americans with access to public accommodations is an invaluable legislative objective. The purpose of ADA is to ensure access to disabled to the public accommodations, provide appropriate remedial action for those who have suffered harm as a result of noncompliance. Although there are times when litigation by harmed individuals is necessary, there's an increasing number of lawsuits brought under the ADA that are based upon a desire to achieve financial settlements rather than achieve the appropriate modifications for access. These lawsuits filed by serial litigants, often referred to as drive-by lawsuits, place exorbitant legal fees on small business. Oftentimes, business owners are even unaware of the specific nature of the allegations brought against them. In early 2011, frivolous ADA lawsuits against small businesses reached an all-time high throughout California. As a result, my good friend and colleague, former Congressman Dan Lundgren, championed the issue and introduced the original Access Act in the 112th Congress. I was pleased to have been afforded the opportunity to take over the legislation for reintroduction beginning in the 113th Congress. In January 2015, I reintroduced the legislation, H.R. 241, the Access Act. H.R. 241 is a cost-free, common-sense piece of legislation and would alleviate the financial burden small businesses are facing, while still fulfilling the purpose of ADA. Any person aggrieved by a violation of ADA would provide the owner or operator with a written notice of violation specific enough to allow such owner or operator to identify the barrier to their access. Within 60 days, the owner or operator would be required to provide the aggrieved person with a description outlining improvements that would be made to address the barrier. The owner or operator would have 120 days to make the improvement. The failure to meet any of these conditions would allow the lawsuit to go forward. Without question, we must ensure that individuals with disabilities are afforded the same access and opportunities as those without disabilities. As a former small business owner and restaurant owner, I personally have had to deal with these serial litigants, and I can say for certain that frivolous lawsuits do not accomplish any goal. Allowing small business owners to fix ADA violations within 120 days rather than waiting for lengthy legal battles to play out is a more thoughtful, timely, and reasonable approach. While the ADA is a national law, as I mentioned earlier, California has become ground zero for ADA violation lawsuits. In fact, California is home to more federal disability lawsuits than the next 4 states combined. A 2014 report determined that since 2005, more than 10,000 federal ADA lawsuits have been filed in 5 states, with the highest disabled populations, 7,188 of which were filed in California. As of 2014, according to the U.S. Census Bureau, 31 attorneys made up 56% of those federal disability lawsuits in California. Those figures are the real-life toll it takes on small business owners, are why I introduced the legislation to allow a fix-it period. However, it is clear that it's not just a major problem in California. The introduction of similar legislation by the gentleman from Texas, Mr. Poe, allows just that. His legislation authorizes a training education component for affected community and certified access specialists, which I certainly would welcome and embrace as an amendment to my legislation. This is also a bipartisan issue supported by states. I was pleased to see that California, SB 269, a text of which I would like to submit for the record as well as a related article, passed unanimously in the State Assembly and Senate and was signed into law by Governor Jerry Brown on May 10th, 2016, just a week ago. The legislation authored by my friend, a Democrat, State Senator Richard Roth, is similar to the Access Act in that it allows businesses to take immediate steps to become accessible by providing them with 120 days from receipt of a certified access specialist report to resolve any identified violations without being subject to litigation costs or statutory penalties. I worry that with California acting to curb these lawsuits, some of these serial litigants will try their trade in other states. Maybe they'll move next door to Arizona. Without question, the Access Act would ensure that the ADA is used for its true purpose of guaranteed accessibility to public accommodations for all Americans while eliminating abusive, costly, and unnecessary lawsuits for small business owners. Once again, I appreciate your time today and stand ready to assist in any way possible to ensure that this legislation moves forward. Thank you.
And I thank the gentleman. In fact, I'd like to thank both Representative Poe and Representative Calvert for their time and expertise. Grateful for your testimony. And I would now like to invite the members of our second panel of witnesses to come forward. want to welcome all of you. Our first witness on this panel is Lee Key. Ms. Key operates and manages a donut shop owned by her mother. Her family's business has been the subject of abusive ADA lawsuits. Our second witness is Millie Shaw. Ms. Shaw is an attorney and a hotel owner in Atlanta, Georgia. Our third witness is Kelly Buckland. Mr. Buckland is the Executive Director of the National Council on Independent Living. And our fourth and final witness is David Weiss. Mr. Weiss is Executive Director, Executive Vice President, and General Counsel of DDR Corp., a company that owns and manages retail properties. Now, each of the witnesses' written statements will be entered in the record in its entirety, and I would ask that each witness summarize his or her testimony in 5 minutes or less. To help you stay within that time, there's a timing light in front of you. The light switch from green to yellow indicates that you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. And before I recognize the witness, it is the tradition of subcommittee that they be sworn, so if you'd please stand to be sworn. And for those of you that can't stand, just do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let the record reflect that the witnesses answered in the affirmative. I would now recognize our first witness, Ms. Key, and I would turn that microphone on if you pull it close to you.
Can you hear me?
Yes, ma'am.
Thank you.
Thank you.
Hi, my name is Lee Key, and I live in Reedley, California. I am here to express my concern regarding the Americans with Disability Act and how it's being used toward all businesses. I understand that all businesses must be accessible for all customers. I have been disabled all my life, and I am grateful for the President George Bush, who recognized the needs for accessibility for the disabled community when he signed ADA into the law in 1990. The public buildings should have accessible entrance doors for both wheelchairs and stroller users. Public facilities that have an eating area and restroom should be accessible with tables wide enough and high enough for a wheelchair to fit. The eating area should not be designated just for the disabled people. An eating area should not have a sign that says for wheelchair only. Accessible buildings allow people with disability to become more independent and self-sufficient. As for me, I appreciate business that have accessible facility. But personally, it does not matter if the grab bar is at 37 inches or at 32 inches on either side, as long as it's providing and it is there and when I need it. All business owners have to recognize the needs for all customers. For example, many businesses provide carpet or rubber mat at the entrance outside or inside to prevent able-bodied customers from slipping. Many business owners are not aware of the changes or new regulation related to ADA. Not all businesses are up to date, up to code with the ADA guidelines of the ADA regulation, because due to the lack of information from our city, states, also federal, not informing the public regarding the changes. My mother has 2 donut shops and has been sued at both locations for alleged ADA violations. It is not fair for business owner to receive a lawsuit package from law firm that is out of our city and county limits. Prior to filing a lawsuit, notification be sent to a business if their facility is inaccessible. That means inside of the building has obstacle or steps or the entrance in the facility is too narrow. Now that business facility is not up to code with the ADA. Therefore, the particular places or business should be corrected immediately with penalty. However, my mom donut shops in the city of Reedley was built in 2000 and do not have architectural barriers. I would know, I am there. All businesses should have 30 days to correct minor violations and 120 days for constructional barriers. In my experience, the carpet or the mats have never become an entangled in my wheelchairs. If the ADA regulation remained the same and require business to remove all carpets or mats for the inconvenience of the disabled people, then the ADA will be creating a hazard for the able-bodied person. We, the disabled community, should not be able to feel segregated from the rest of society. This will create bitterness between the customer and the business. I do not need a sign to inform me that I am disabled and where I should sit. The ADA should concentrate on the accessible curves and ramps that do not wrap around the building and the back door access only. Generally, when I enter through the back door, I feel like business are embarrassed or ashamed to associate with me because of my physical limitations. This is understandable to a point because there are a few disabled individuals, including lawyers, that make it their personal mission in life to collect money from businesses that they have never been to. It seems this handful of lawyers think they are only helping the disabled community, that they are helping the disabled community. Moreover, they are separating the disabled community and the able community. The lawyers are causing the able-bodied community to dislike the Americans with Disability Act. This makes the rest of small business owners who are trying to earn an honest living look bad. Throughout my life, people are generally very helpful. When I am out and about in the community, people offer their kindness to assist me. Whether I accept or decline is up to me. I also have a voice if I need assistance. I can ask for help. I do not want business owners to cringe when I see me enter their establishment. Personal experience, I was at downtown State Capitol and had to use a restroom. I spotted a bar and a restaurant, and I asked if I could use the restroom. Then they asked me if I'm going to buy a drink. My aides responded, no, she does not drink, but she needs to go to the restroom. No, they did not give me permission to use the restroom. Since the ADA lawyers are going to sue small business, they are posting signs on their windows, no public restroom. I'd like to see the ADA regulation or federal laws to be fair and not be taken advantage of or misused by people that know the laws, such as lawyers and certified access specialist person. I believe our elected officials and city inspectors should inform the public of all new laws and changes. If this is unnecessarily money-hungry ADA laws should continue, many businesses will be forced to shut down, and there will be many empty buildings in our community because they do not have the money to pay off the lawsuit. To me, this is wrongdoing and misusing the ADA. I noticed the Governor Jerry Brown's signed SB 269, which eliminates minimum statutory damages for certain minor or technical violations of the ADA. In my opinion, lawsuit is still a lawsuit. It doesn't matter if the amount is reduced. Thank you.
And I thank you, Ms. Key. And I now recognize our second witness, Ms. Shaw. And Ms. Shaw, is that microphone on?
Chairman Franks.
Ms. Shaw, would you turn that microphone on?
It is on. Chairman Franks, ranking member.
Ms. Shaw, you may have to bring that closer to you. I'm not sure what.
Can you hear me?
Yes, ma'am.
There we go. Chairman Franks, ranking member Cohen, and distinguished members of the subcommittee, thank you for the opportunity to testify today. It is an honor to appear before you to share my story. My name is Millie Shaw, and I am a second-generation hotelier and attorney from Georgia. My parents migrated from India in the 1980s and bought their first hotel in Milledgeville, Georgia. I spent the first 8 years of my life on the third floor of Days Inn, a place I called home. 30 years later, my family owns several hotels that employ nearly 400 people. I personally own 2 hotels in Atlanta, Georgia that amount to nearly 150 guest rooms and employ over 20 dedicated employees. I am also here representing the Asian American Hotel Owners Association. AHOA members own over 40% of all hotels in the United States and employ over 600,000 American workers, accounting to $10 billion in payroll annually. Recently, small businesses have come under attack by unscrupulous attorneys and professional plaintiffs seeking to make a quick buck. To advance their corrupt goals, these bad actors manipulate one of the most important civil rights laws in our country, the Americans with Disabilities Act. I was recently sued for allegations and violations of the ADA at my hotel in Atlanta. I was surprised to think that a guest at my hotel was denied service. I contacted the general manager to learn that the plaintiff had never actually stayed at our hotel, nor was there any evidence that he or his attorney had visited the property. The claims in the complaint were extremely vague and general. Among several broad issues, he stated a failure to provide accessible entry into our hotel's pool. My swimming pool at my hotel has been closed since the day I purchased it. It is empty and covered with a tarp. Was I being sued for failing to provide entry into a part of my hotel that has always been closed to the public? I researched the plaintiff and his attorney and found out that they have sued nearly 100 businesses, and each suit is almost identical. In fact, the same plaintiff and the same attorney has sued my father with the same complaint at one of his hotels. It is clear that this plaintiff has no desire to stay at the properties and that the attorneys are using him as a proxy. I now have two options. I can either fight the suit, subject my business, employees, families to months of intrusion and litigation and pay thousands of dollars in defense fees, or I can settle with the plaintiff and pay his attorney thousands of dollars, in which the attorney will likely be the only one with the financial gain. We cannot afford to pay out settlement after settlement and defend against meritless suits aimed at preying on our fears. Hoteliers are targeted because so many of us are minorities. Settling would imply that I'm guilty of violating a civil rights law. It would send a signal to my customers that my hotel is substandard and that I do not care for my guest. An adverse decision could impact my ability to attract new customers and to finance additional properties and grow my business. It is a no-win solution. We need to find a solution that discourages attorneys from abusing the ADA for dishonest purposes. H.R. 3765, the ADA Education and Reform Act, is a vehicle that balances the important protections conferred by the ADA with affording small business owners the opportunity to address any issues that may exist. The bill requires a detailed description of a potential problem, a requirement to provide notice, and a cure period in order for the owner to recognize and address the areas of concern. It will also provide a collaborative solution that promotes improved accessibility. Mr. Chairman and members of the committee, thank you for the opportunity to testify before you today. I appreciate your listening to how an unscrupulous attorney has targeted me and several others in an effort to extort money under the guise of promoting accessibility under the ADA. We are hoteliers. We are in the business of hospitality. The crux of our industry is to provide a welcoming, comfortable, and enjoyable environment for all of our guests. I ask you to consider my story when evaluating H.R. 3765. Please help protect small business owners like myself who simply want to run our business free from the fear that the next envelope we open might be a lawsuit that closes the doors to our hotels. Thank you.
And thank you, Ms. Shaw. And I would now recognize our third witness, Mr. Buckland. And Mr. Buckland, is that microphone close to you and on, sir?
Can you move it a little? Can you hear me, Mr. Chairman?
Yes, sir.
Mr. Chairman and Ranking Member Conyers and members of the subcommittee, my name is Kelly Buckland. I'm the Executive Director of the National Council on Independent Living. NICL is the oldest cross-disability national grassroots organization run by and for people with disabilities. We go by NICL, right? NICL membership includes people with disabilities, Center for Independent Living, statewide independent living councils, and other disability rights organizations. NICL advances the independent living and the rights of people with disabilities, and we envision a world in which people with disabilities are valued equally and participate fully. Centers for Independent Living address discrimination and barriers that exist in society through direct advocacy. These barriers are sometimes architectural, but more often reflect attitudes and principles that have been reinforced for generations. They have deterred people with disabilities from working, leaving many in poverty, and unjustly detained in institutions. As my own life experience has proven, with increased opportunities, individuals with disabilities can claim their civil rights and participate in their communities in the same way that people without disabilities do. I broke my neck in a diving accident on July 26, 1970. I have used a wheelchair ever since. Coincidentally, the Americans with Disabilities Act was signed into law on July 26, 1990 by President George H.W. Bush, exactly 20 years to the day after I got my disability. Therefore, I had 20 years of experience living with a disability prior to the Americans with Disabilities Act. And now I have 26 years of experience living with a disability post-ADA. Fortunately, the ADA has literally changed the face of the globe. Although I'm honored to be here, I am here to testify in opposition to these so-called ADA notification bills. As Congressman Sensenbrenner, Conyers, and Nadler know, the original ADA and the 2008 amendments, which were passed and signed into law, passed because people with disabilities, bipartisan lawmakers, and businesses worked together. The various efforts to make it harder to bring a Title III lawsuit have never followed the same process and never enjoyed support from people with disabilities or the organizations that support them or the organizations that represent them. People with disabilities don't want more lawsuits. We want more accessibility. Adding a notification requirement won't make the multiple lawsuit phenomena go away. It simply sends the message to business owners that they don't have to worry about complying with the ADA until they get a letter. In most parts of this country, it is very difficult to find a lawyer who is interested in bringing an ADA complaint against a place of public accommodation because they can't collect damages. When the ADA was enacted as a compromise between the disability and the business community, the disability community gave up the ability to obtain damages under Title III of the ADA by allowing injunctive relief and attorney's fees. Unfortunately, there are still businesses and companies who have yet to comply with this important civil rights law even after 26 years. The problem here that these bills are trying to address have little to do, if anything, with the ADA. Title III, does not provide for damages. Settlements or court orders only can involve attorney's fees. And in the states that some of the witnesses are from, those state statutes, like California, which has been mentioned, allow the people to get damages. That's why California changed this law. Damages aren't allowed in the ADA. There's no need to change the Americans with Disabilities Act. There's lots of information out there. There's lots of technical assistance people can get on how to comply with the law. There's even a phone line you can call in to get information, and there's a website. There's lots of free technical assistance to businesses who actually want to comply with the law. The ADA does not require businesses to do anything that would be considered an undue burden, which means that it's not readily achievable, that it is readily achievable and it can be accomplished without much difficulty or expense. And I just want to say some of the stuff that's been, I'm going to not go through the rest of my written testimony, but some of the stuff that's been talked about around building stuff and people needing to become in compliance. The state that I hail from, Idaho, we changed the building code in the state so that when people do get a building permit, their building is going to be built according to the Americans with Disabilities Act. And the act really gives people ranges that they have to put stuff into. Like, for instance, Ms. Key can fit under this table. I can't. That's why the act allows for ranges instead of exact numbers that have to be met. So with that, Mr. Chairman, I know my time is running out, but just in closing, I would like to recognize Yoshiko Dart, the wife of Mr. Justin Dart, who is known as the father of the ADA in the building. With that, Mr. Chairman, thank you very much.
And thank you, Mr. Buckland, and welcome. I would now recognize our fourth and final witness, Mr. Weiss. And sir, is that microphone on or close?
Yes, can you hear me?
All right, yes, sir.
Good morning, Mr. Chairman, Ranking Member Cohn, Mr. Conyers, and members of the subcommittee. My name is David Weiss. I'm Executive Vice President and General Counsel of DDR Corp. I've been in practice for almost 30 years and General Counsel since 2003. DDR is a New York Stock Exchange traded real estate investment trust. We own over 350 properties around the country in Puerto Rico and have over 113 million square feet. Our tenants are some of the most recognizable national, regional, and local retailers. I'm here to testify today on behalf of the International Council of Shopping Centers, or ICSC, the global trade association for the shopping center industry. With over 70,000 members in over 100 countries, they represent a wide variety of owners, managers, and other professionals related to real estate. First and foremost, let me say that the ICSC vigorously supports both the letter and the intent of the ADA. We recognize and applaud the positive impact that the ADA has had on our society. We also support H.R. 3765, introduced by Congressman Poe and co-sponsored by Congressman Peterson, as ways to strengthen accessibility, the primary goal of the ADA. Frankly, I think the legislation that we're talking about today is misunderstood. There's actually quite a bit of agreement related to the legislation. As Mr. Buckland noted, people with disabilities don't want more lawsuits, they want more accessibility. Frankly, we couldn't agree more. We all share the goal of more accessibility. We want full compliance, we want it faster, with less cost, and we want more resources, not less, devoted to improving accessibility. As an industry, our interests are aligned with the goals of the ADA. First of all and foremost, it's the right thing to do. Many of us have experienced the challenges faced by family and friends who are disabled. Second, it's in our economic best interest to do so. There's a fundamental misunderstanding and misconception that businesses don't support or want to comply with the ADA. Let me be very clear. More people visiting our shopping centers and properties is a good thing. We work with our tenants exhaustively to find ways to encourage more, not less people to come to our properties, and we spend millions of dollars each year to accomplish this. Let me be clear again on an area where I think there's also agreement, and that relates to the bad apples. For those persons who flaunt the ADA, they deserve the full weight of enforcement. If they choose to ignore compliance and a lawsuit and the threat of attorney's fees is the only way to force compliance, then so be it. But on the other hand, if a simple notice is the fastest and cheapest way to solve many unintended and often minor areas of noncompliance, why would we not encourage that? Unfortunately, not everyone agrees with Mr. Buckland. Lawsuits by a small group of lawyers have skyrocketed. 63% increase from 2013 to 2014, over 4,700 lawsuits filed in 2015. Unfortunately, there are some whose interests are not aligned with the ADA. These attorneys take a different approach. They file first, ask questions later. They sue, settle, and move on. Their interest is not in actually improving accessibility, but rather only in only earning attorney's fees. Many never visit the property, can't tell you what violations may be there, and never bother to confirm whether any alleged violations have been resolved. So why do we support this legislation? Because it gives the good apples a 60-day window to respond to claims without an immediate lawsuit. It gives 120 days for the opportunity to cure any potential violations. I think we can all agree that this is the fastest, most efficient, and most cost-effective way to achieve compliance. And secondly, let's not forget that it also enhances education and training and encourages the use of alternative dispute resolution to actually speed up enforcement. And then let's also be clear about what this legislation does not do. It does not stop the right to sue for noncompliance. It does not limit the ability to recover attorney's fees. It does not change the Department of Justice enforcement rights. It does not change state laws. What it will do is encourage compliance and stop the unfortunate abusive tactics of a few. With that, I thank you for this opportunity to testify today, and I look forward to answering any questions that you might have.
Thank you, Mr. Weiss, and thank you all for your testimony. We'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. And Ms. Key, if it's all right, I'll begin with you. Mr. Key, Mr. Poe's bill requires a plaintiff to give a business owner notice of an alleged ADA violation and the opportunity to fix that violation before a lawsuit may be filed. As a business owner, as someone disabled, do you believe it's fair to the disabled to require notice and an opportunity to fix a violation before a lawsuit can be filed?
It's fair to insert itemized. The reason I believe it is fair because there's so many new update law and regulation that all of you had written to. For example, for my mom's shop, there were 7 items unnecessarily, It was a sticker note that for the vision bill for the exit sign, the incorrect symbol of the restroom, the doorknobs, the mat, that is simple. I was not aware of the new regulation. So if you all that making changes, let us know. And this will not happen. If the community, if the citizen knows, this will not happen. I would like to say something. I don't think your building here is accessible. I went to the women's restroom. It's not accessible. And you guys create and make the laws, and your building's not accessible. So how do you expect a normal citizen to follow your rules if you're not doing it yourself?
Thank you, Ms. Key. Ms. Shaw, critics of legislative efforts to allow for a cure period prior to commencing a lawsuit under Title III of the ADA have argued that the property owners have a legal obligation to ensure their property is accessible to the disabled. These critics argue that a notice and cure legislation would create a further incentive for property owners not to comply with ADA until they're sued. And how would you respond to that criticism?
Thank you, Mr. Chairman. I would respond to the critics by saying that the fact that they're having an issue with the grace period to begin with shows and implies that they're not here to promote accessibility. All of us here in this room support the ADA, support Americans with disabilities. We promote it. We think it's great for America. In fact, we want to fix any issues because ultimately that attracts customers to our business and we want to grow our business. So we're automatically incentivized. So a notice and cure provision would help us fix any areas of concern and promote the accessibility versus just the attorneys filing lawsuits immediately to get attorney's fees.
Thank you, Ms. Shaw. Mr. Weiss, has there been an increase in ADA litigation under Title III? And if so, could you provide the committee with some background on that increase?
Yes, I'd be happy to. Yes, the number of cases has grown dramatically over the last few years. And frankly, that's really the driving need for this legislation. This is both a growing and expanding problem, and actually just continues to grow. As I mentioned in my opening remarks, there's been a 65% increase from 2013 to 2014, and the numbers just continue to grow and grow. In particular, there are certain states where these cases are growing the fastest: California, Florida, New York, Texas, Arizona. Those combined had the largest number of suits filed, over 80% of them filed nationwide. California has approximately 40% of the lawsuits, but only, frankly, about 12% of the disabled population there. So this is an ongoing and continuing problem.
Well, thank you, sir. And I will now recognize the ranking member, Mr. Cohen, for 5 minutes.
Thank you, sir. Mr. Weiss, is the fact that California's got their state law, and I think I heard that it includes damages, could that not be the reason why there's so many of those cases in California?
No, I don't think so. Obviously, the ADA has been in effect for 25 years. I think we all would agree it's had a dramatic impact across the country, so much so that it is just a part of the way of doing business. In our industry, it becomes second nature. We are constantly updating our properties and ensuring compliance with them. The issues that we're having here are very specific, and this legislation was...
But let me ask you this, and we have a little bit of time. Why do you think California is particularly litigious? That's the question.
I can't tell you exactly why some states over others, but I can just tell you that it's growing nationwide. Those happen to be where the most
specifically, you
are.
mentioned Texas, Arizona, California, and Florida. There's got to be some... Aren't those the states you mentioned?
That's where there are the most cases, but there are cases across the country.
I'm hip to that. But the fact is, there's got to be a
without...
reason why those 4 are more than the other 46. You don't have a thought. Mr. Buckland, do you have a thought?
Mr. Cohen, I do. Those are the states that allow damages.
All 4 of those states allow
Coincidentally,
damages?
Yeah.
How many other states allow damages, you know?
There's about 10 in total.
So if there's
There's,
10 total, and these are 4 of them, that seems like what they've got in common. And that's not a national problem. It seems like that makes, it's not a, Ms. Shaw, you grasp that, do you not? You grasp the fact that those 4 states are 4 of 10, and that might be the unifying or unique factor that causes the burgeoning lawsuits there, and not something with the ADA in general?
Sure, but it's prevalent across the United States. You know, their properties, my properties in Georgia, and the same attorney and the same plaintiff has filed the same lawsuit 100 times.
In Georgia. Is he a
In
Georgia
Georgia.
lawyer?
Correct, yes.
Yeah. Let me ask you this. You heard what I was saying in my opening remarks about the possibility of having some type of damages for the folks that don't comply if there was a notice provision. Would you agree that there needs to be some type of a stick to punish more harshly with some sanctions the folks that don't comply within the 120-day period?
Yes, and the whole idea is that you would be able to file the lawsuit.
But that's already available. Shouldn't there be something extra?
Such as what?
Such as sanctions, damages, liquidated damages, some amount of
Yeah,
the
I mean, exactly. You can uphold that and impose sanctions, but remember, at the same time, we're also trying to run our business. And so we're doing the best we can.
But you're a good guy. I'm talking about the bad guys.
Of course, the bad guys do need sanctions.
Right. So you would agree that, and Mr. Weiss, do you agree that that would be something that would make your proposal better?
Well, frankly, let me start on this damages issue, which you've raised before. First of all, we are not talking about making changes, fundamental underlying changes to the ADA. We're talking about legislation which is narrow and focused to a particular abuse for an existing enforcement mechanism. Secondly, I'm not sure that damages actually will reduce the problem. In fact, it may well encourage them. More damages means more lawsuits. More lawsuits means more attorney's fees. It means more time and resources spent on lawyers rather than what we're trying to do.
Damages are only for the people that didn't comply with this program. You know, your program does have a lot of beneficial purposes, yours or Ted's or whoever's it is, but I can see the benefit in getting compliance. But for the folks that don't comply, why not? The damages isn't going to be a problem for the good guys. It's only going to be for the bad guys. And bad guys always have to be punished.
I think your underlying assumption is that this is only a damages issue. Take Florida, for instance.
No, I'm not saying it's only a damages issue. It's probably a damages issue because if where the litigation has exploded, but what I'm talking about damages is a way to have another lever out there to make people comply. All you've got is the notice. What you make is harder to bring a lawsuit and disincentivizes lawyers from being involved in the process, which will probably result in less notice of actual problems. So if you're going to do that, do something that doesn't, you don't want to have an overkill and help the good guys at DDR, but not the bad guys at EEQ.
With all due respect, Mr. Cohen, I don't think this inhibits the enforcement of the ADA. I think it actually it helps enforcement, and here's why.
Mr. Buckland, Mr. Buckland, why do you think it inhibits people from coming forward?
Absolutely. There's no other civil rights statute that requires notice to be able to fix the problem before you can bring suit. No other civil rights, but they're wanting to put it in this one. It absolutely. I'll give you a couple of examples. Like, I was in Virginia Beach. There's a timeshare down there. And if we sat through I'm sure a lot of you have experienced this, if you sit through a presentation, they give you some reward, right? So the reward was to be able to go on this whale watching tour. So we sat through me and my wife and my son sat through the presentation. They gave us our whale watching tickets. And by the way, none of the timeshares, I couldn't have purchased any of the timeshares because they're all inaccessible. Not a single timeshare didn't have a step in front of it. So they're all inaccessible. So then we go to the whale watching tour, and they tell me they don't take people with wheelchairs on their tours. So I talked to the guy that took the tickets and said, "You aware of the Americans with Disabilities Act?" He said, "Yes. That doesn't apply to us." I said, "Where's the manager? Could I speak to the manager?" "I'm the manager." I said, "You still don't think the ADA applies to you?" And he said, "No." So when I got back home, I talked to the Department of Justice, and we went into where you work it out between you. We did that. They, with very little expense, built a ramp to the boat. Now they take people with disabilities on their whale tour. Another one that just happened like very recently is there's a business association here in Washington, D.C. that I went to. Could not get in. The front entrance is not accessible. Couldn't independently enter the building either. I told them all of that. I gave them resources to get information on what the fixes were. I checked back with them at about 2.5 months later to see if they'd made any progress on making their building accessible. I got no response. So I waited for about another 2 weeks, sent them another email asking if they had made any progress. No response. I did that 3 times with no response. So then I made a phone call. They weren't in, so I left a message. No response to my phone call. Frankly, that is most of the responses that you get from when you notify people that there's a problem, you don't get any return response. That's what's happened to me over and over. It's what's
Thank you,
happened to
sir.
my
I
colleagues.
appreciate it.
No,
My
Mr.
time's
Chairman,
out.
expired.
Thank you.
Thank
And
you.
now recognize the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman, and I thank the witnesses for your testimony here today. I'm just thinking about how the Americans with Disabilities Act in a way changed my life, and I want to put this narrative into the record. I happen to have been the only public building in the community that was wheelchair accessible right after the passage of the ADA. And so they came and asked me, would you be the host of the Republican caucus in your community? And I said, sure, I'm happy to open up my doors and help people out. And then I became the chairman of that caucus, and now here I am in Congress. So I just slipped that in as I don't know how many different implications there are. I'm sure it's affected your lives a lot more than it's affected mine. But it's ironic that if that meeting had never taken place, who knows what I'd be doing today. So I wanted to ask, and I wanted to ask especially Mr. Buckland, and I'd ask if you could be brief in your analysis of this, but you lived through 20 years prior to the ADA in a wheelchair and 26 years afterwards, and you probably didn't see the immediate results of that because we had a lot of new construction that took place and refurbishing that took place. So I don't have any doubt that it's changed a lot of accessibility, and you've seen it incrementally from your eyes. The question back then in 1990 was, do we require compliance with the ADA only on new construction or also for existing buildings and facilities? And I recall going in and doing curb cuts and making wheelchair accessible. And I'm wondering, why didn't we think of that when we built that sidewalk in the first place? It was really it was a huge oversight on the part of our society not to see how simple and how cheap that part of the ADA could have been. But what would it be like today, do you think, if the ADA had been written in such a way that new construction complied, but old construction was voluntary? What kind of progress do you think we would have made in the last 26 years?
Mr. Chairman, Mr. King, very little. I mean, if you walk around this town, most of this is old construction. So if we hadn't applied the ADA to existing structures, nothing here would be, or not nothing, but a lot of the buildings here wouldn't be required to comply.
It's okay. So you think, and these buildings especially, I've got some of the oldest buildings here, and in my neighborhood it would be different for different reasons. We have a lot of new sidewalks and a lot of new curb cuts would have been done. But I want to ask you in your perspective, and you've given it to me, and I appreciate it. Then I'd like to turn to Ms. Shaw, and you mentioned that there are essentially a copy and paste 100 lawsuits from a single lawyer, and those lawyers in many cases, it's either you or Ms. Key, that said that the lawyers had not been in the facility. So I'll ask you each of you, but I'll go first to Ms. Shaw. What does that list of plaintiffs look like? When you've got a lawyer with 100 suits that are copied and pasted, what's the list of the plaintiffs look like on each of those suits?
In my case, it's just one plaintiff, and so the attorney is using that one plaintiff to fish out other properties in the area and slap the same lawsuit on them.
And have you looked at the plaintiffs in those other lawsuits that were filed by the same attorney? Could it be the same plaintiff in some of those cases, or even all of them?
Absolutely, yes. And in this case, it is the same. I mentioned that my father received the same lawsuit, same number of pages, same attorney, same plaintiff at his property.
Okay, but there are 98 others out there. What's the likelihood that that same plaintiff has also been utilized by the same attorney in a number of other cases in addition to you and your father?
There is a likelihood that there's the same plaintiff, same attorney. There's also other plaintiffs and other attorneys. So
Yeah.
it's an ongoing case, right? I mean, you can have one plaintiff suing 100 properties using the same attorney. And that same attorney may want to settle 100 properties and you average $5,000. That's a lot of money.
Okay, so I'm just trying to get this concept of how this works in the attorney's office. You have an attorney that is a hotel chasing attorney, and he decides, I've got a potential plaintiff here, I'm going to contact him, and the two of us can go together, and now we'll file potentially 100 lawsuits, and you be the plaintiff, I'll be the attorney, and we'll collect this money at the expense of the businesses that never had a chance of a notice to cure, never an opportunity to even know that they were potentially out of compliance with the ADA. So I look at that and I think, had these plaintiffs then, what's the likelihood that the plaintiff had never been in the building before the suit was filed?
I think each case varies. In my case, I looked back 1 year to check the reservations if the first name and last name ever matched, and there was no record of that person ever staying at our hotel.
Ms. Key,
Yes, sir.
would you concur with the testimony of Ms. Shaw in your experience?
Yes, on that particular day, this individual sued 3 locations in our city, same person, and he does not live in the city. And that particular day, I was not at the shop. I came back from doing my errands, and I got a package, and I asked everybody, who is this person? No one knew who he was. I even asked a medical facility that does provide wheelchairs, just to make sure if he's, in the register with them or buy anything from them, they don't even know who he is. And recently, they did a kind of investigator on these individuals. He is an able-bodied. He sit in the wheelchair. He go to places, and he uses wheelchairs to get what he does, and he lifts his wheelchair to put back in his truck. He has no...
Isn't that fraud? Would you say that's fraud?
That is very fraud, and that's why we're here, is that we need to stop this. We need to stop this fraud. We need to stop this ridiculous using ADA to get what they want. Mr. Buck said that this facility, he contacted 3 times and they no respond. Please, go sue them. Double the price, whatever that need to be done, yes. But, give us a chance, like us, myself, or Ms. Shaw, that we don't have any barriers in our facility. No barriers, just because we don't have the information that you folks changes. The lawyers has no right. It's not a barrier. If it's a barrier, please come after us. We have no problem.
Thank you very much. I thank the witnesses and yield back.
Thank you, gentlemen. And I would now recognize the ranking member, Mr. Conyers, for 5 minutes.
Thank you, Chairman Franks, and I thank the witnesses. Could I begin by asking unanimous consent to enter into the record 14 letters from organizations that have a variety of objections to the measure that we're examining today. The Consortium for Citizens with Disabilities, Paralyzed Veterans of America, the Leadership Conference on Civil and Human Rights, and plenty of others. Could I ask unanimous consent? They take strong exception to this measure, and I ask that these letters be included in the record.
Without objection.
Thank you, Mr. Chairman. I wanted to just ask Mr. Buckland if, we're all friends here, if Mr. Weiss's testimony raised any objections in terms of your experience as someone that's disabled.
Well, Mr. Chairman, Mr. Conyers, I mean, the whole issue around the written notice and you have to wait a certain time for it to cure, all that stuff, like I said in my testimony, I think that will incentivize businesses to not do anything till they do get a letter. So, yeah, I take exception to that. I also think that, like, just naming the number of lawsuits doesn't mean that's a bad thing. If those businesses were out of compliance, then why is that a problem that they got sued for being for breaking the law? I don't quite understand that. So there was no mention about whether or not they were valid complaints. They were just the numbers. So I'm not sure that that just results in it being a bad thing.
Would it be helpful if the committee knew what the results of all those lawsuits were?
Yes, I think it would. And then I also think that the Department of Justice could provide this committee with some information about how many complaints they've received, what the complaints were about, how the complaints were resolved, that sort of stuff.
Mr. Chairman, I'm hoping that we might be able to follow through on both my suggestion and Mr. Buckland's in terms of getting a little bit more detail on some of these cases. Now, Mr. Buckland, we have 4 witnesses here this morning. You're the only one that is opposed to this measure, and so I wanted to ask you, what does the pre-suit notification mean for the private enforcement of the ADA, and what would happen if enforcement is left only to the Attorney General if private lawyers stop bringing cases?
Well, I think you stated the obvious, Mr. Conyers, like what will happen if our ability to file suit is impeded, then we have less enforcement. And like I mentioned before, the businesses will just wait till they get a letter. Our experience really has been, as I mentioned, it's difficult to find attorneys that will take cases, except for those states that allow damages. And so I think this is really more of a state legislation issue than it is with the Americans with Disabilities Act.
Mm-hmm. I do too. Proponents now of pre-suit notification argue that it's reasonable to give businesses the opportunity to cure a violation before a lawsuit commences. But how might such a notification scheme affect voluntary compliance?
Well, again, it would impede our ability to make businesses comply because you'd have the waiting period, the notification. It would disincentivize attorneys. But I want to ask the opposite question. Why do they need to be notified? The Americans with Disabilities Act is out there. There's lots of information about how you comply. I mentioned that before. There's 10 ADA centers, 1 in each region of the country, and they have expertise on the Americans with Disabilities Act, what it requires to comply. They'll even come out to your business and talk to you about what you need to do. So they should be proactive, and they know the law's there. They should get the technical assistance. They should come into compliance.
I think that's a very good response, and you've answered all my questions very appropriately. And, Mr. Chairman, I yield back the balance of my time.
And I thank the gentleman, and I now recognize the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman, and thank you for holding this hearing. The Americans with Disabilities Act fundamentally changed our society for the better. It both literally and figuratively opened the doors of public life that had been closed for too long. And I believe that any efforts that we undertake to address abuses under the current law have to protect the progress that's been made, and we have to continue to ensure that our society is open to everyone. The goal that we all share is widespread compliance, full compliance with the ADA. Retrofitting older construction, ensuring that all new construction is built inclusively from the start, has always been the guiding principle. And I appreciate that the original compromise that created the ADA was designed to balance our national interest in accessibility with a desire to make private businesses allies in this endeavor rather than our adversaries. And I don't want to upset the original balance that makes it, that in any way that would make it harder to work together toward our common goal of compliance. But I believe that we have to exercise strict oversight to ensure that we're achieving continued progress to accessibility. That's what the ADA is meant to provide. And if abuses of the process work against those goals, then I think it requires us to stop and pay attention. In Florida, which we talked about earlier, in my own state, more than 1 in 5 ADA claims filed last year originated in the Southern District of Florida. And businesses have to retain the right to do the right thing. And there has to be an incentive for them to do the right thing. The threat of a lawsuit is powerful, and it works. But for honest, good faith actors who are making easily correctable small fixes, things that would take a few minutes to remedy, we have to have a process that allows them to make these fixes, to adjust a grab bar, to rehang a coat hook, and to be able to do it quickly without a lawsuit. I don't take the idea of good faith lightly. It should be difficult, a difficult standard to meet. It should show that businesses are in partnership with the American people in creating a society that is accessible and is welcoming to everyone. That public life is for everyone, and we want a society where small businesses can thrive doing business with everyone. Now, Mr. Weiss, I've been told that some of the worst of the repeat plaintiffs don't even bother to follow up to see if the infractions have been corrected, which tells me that complaints often are more about extracting money than about making a facility more accessible. The code enforcement officer in Delray Beach, in my own part of South Florida, was quoted as saying, they don't care if you fix it or not. The businesses pay between $5,000 and $12,000, and it goes away. People are taking complete advantage. It's a moneymaker. It has nothing to do with compliance. Yep. In your experience, what's been the follow-through of plaintiffs post-settlement?
I'm sorry.
Turn up the mic. Yep.
I'm sorry to say it's virtually none. And that's part of the problem. We spend millions of dollars ensuring our properties are code compliant and compliant with the ADA, and we have millions of dollars invested, and then we have attorneys essentially that come to us with their hand out, not knowing, with vague claims of noncompliance. They don't have specifics, and they never bother to follow up as long as you have paid to settle the suit. As a follow-up, I guess I would just mention, both in your district, Mr. Deutsch, this has become, this is not just the ICSC issue. There are press reports. There was one, in fact, this week of a serial plaintiff filing 1,000 lawsuits. In response to Mr. Cohen's reference to lawsuits in California, California has actually passed 2 pieces of legislation to actually try to curb the abuse of these lawyers, even with the damages provision that he thinks will actually help. There are abuses going on, and so California has passed legislation as well to try to limit the abuses that are occurring there.
Hey, Mr. Buckland, isn't there a difference between a business owner who refuses to include a required number of handicap spaces, or who refuses to make their restrooms accessible, and a business owner who runs a business who has followed all of the technical assistance as best as he or she could, and the grab bar is 2 inches too high, or the paper towel holder is a couple of inches off, or the line on the handicap parking space that is there is drawn slightly crooked. There's a difference between them, isn't there? And shouldn't we incentivize, don't we want the people in the bad actors to actually have to do what's necessary, and lawsuits absolutely are required to get them to do it? But shouldn't we require or give an opportunity to the small business owner who used all good faith to comply with the law, the opportunity to fix something when it might take 5 minutes to fix, instead of making them pay $10,000 or $12,000 when a lawsuit is filed?
Mr. Chairman, Mr. Deutsch, with all due respect, if it's if there's only, the only issue is the grab bar is 2 inches off, the business fixes that, there's no, if you're, unless you're in a state with damages, there's no money paid out.
Well, Mr.
You would
Buckland-
only collect,
No, excuse me one second.
just to
No,
follow
but I
up.
just want to correct that, and maybe I misunderstand, but the stories I've heard from the businesses in my district, where in South Florida, where 1 in 5 of these cases are filed, the story I heard from the guy who runs the bagel shop that I stopped in the morning, who just shared another one of these stories with me, said he got hit with a lawsuit for one of these very minor mistakes. He's used all good faith to try to comply, and you're right. He's going to raise it by those couple of inches, and it's going to cost him $10,000 in plaintiff's legal fees, which is a cost that he never should have had to incur.
Well, I'm sorry, unless he's like somehow fought against the original complaint, why would there be attorney's fees?
Mr. Weiss, can you answer that question?
The answer is because the suit's filed before the business owner even knows what the issue is. So to get rid of that lawsuit, you end up settling it.
Right, and I think the chairman understands this, and the ranking member of the committee understands. There's no one on this committee who fights harder to keep the courtroom doors open for people who deserve justice in this country than I do.
Believe me, he's telling the truth.
But in this situation, all I think we're looking for is the opportunity for a small business owner to be able to, who's exercised all good faith and has only tried to do the right thing, to be able to continue to do the right thing without being forced to pay an extravagant amount of money. Give them the opportunity to fix it, and they will. Anyway, I really appreciate the panel for being here. I think it's a really important discussion. Mr. Chairman, I yield back.
And I thank the gentleman, and this concludes today's hearing. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And I want to thank the witnesses and thank the members and thank the audience for being here, and this hearing is adjourned.